Reduction of share capital, section 66. When the share capital of the company reduces with NCLT approval, it is called reduction of share capital. When it is reduces without NCLT approval, it is called diminution of share capital. Diminution of share capital includes forfeiture, surrender, buyback, redemption of preferences, cancellation, compulsory buyback by order of NCLT, in prevention of operation and mismanagement. There are some important points on reduction of share capital. Authority for reduction of share capital needs to be there in the AUA of the company. If authority is not there, then the company needs to alter its AUA by passing special resolution. Regulatory framework includes two things. First is section 66 of Companies Act 2013. Second is NCLT, procedure for reduction of share capital of company. For capital reduction, company need to pass special resolution and need to obtain confirmation order. The regulatory framework for capital reduction is applicable upon company limited by shares, company limited by guarantee and having share capital. Requirement of capital reduction under section 66 is not applicable upon unlimited company, and therefore in case of unlimited company, the reduction of share capital shall be as per AUA. Company can reduce the share capital in any manner, and therefore selective capital reduction shall be allowed, unlike buyback share where selective capital buyback is not allowed. There are some common methods. First is by extinguishing the liability, by reducing the liability of shareholder to extent of unpaid value of shares, by adjusting or cancelling the paid of share capital against fictitious assets or capital loss, by reducing the surplus fund of the company to the shareholders which have an effect of extinguishing or reducing the liability of shareholder, by returning the surplus fund of the company to the shareholder without extinguishing or reducing the liability of shareholder. If the reduction of share capital results into alteration of MOA, then company is required to alter its MOA by reducing the amount of the share capital and number of shares. Reduction of share capital shall not be affected by company if the company is in arrears with the repayment of deposit accepted by the company either before or after the commencement of Companies Act 2013 or any other interest thereon. For capital reduction, an application need to be made to NCLT for obtaining its confirmation by filing petition along with the scheme of proposed capital reduction. NCLT on receipt of such application in form of petition shall give notice of such application to central government, ROC, creditors, SEBI in case of a listed company, and in all conditions. The aforesaid persons are required to submit their representation to NCLT within 3 months from the date of receipt of notice. However, if no representation being made to NCLT within the said period of 3 months, then it shall presume that they have no objection to the proposed scheme of capital reduction. NCLT, before confirming the scheme of capital reduction, shall ensure that the debt or claim of every creditor of company has been discharged or determined or has been secured or consent of such creditor being obtained. NCLT shall not issue its confirmation order for the proposed scheme of capital reduction unless the auditor provides a certificate confirming that the accounting treatment under the proposed scheme of capital reduction is in conformity with the accounting standards specified under section 133 of the Companies Act 2013. NCLT confirmation order confirming the reduction of share capital shall be published by the company in such manner as NCLT direct. The company shall file the certified copy of NCLT confirmation order along with minutes approved by NCLT to the ROC within 30 days of the receipt of NCLT confirmation order. Such minutes duly approved by NCLT shall specify the following: amount of share capital, number of shares, face value of each share, amount of paid of share capital, both pre and post capital reduction. ROC shall register the NCLT confirmation order confirming the scheme of capital reduction and shall issue a certificate of registration which shall be conclusive evidence that all the requirements of capital reduction has been duly complied with. After issuance of ROC certificate of registration, if any procedure defect being discovered, then it shall not invalidate the capital reduction and the same shall be remain to be valid and binding. There are two cases, Walker and Smith Limited, latest is Assam versus Pulpro. In any officer of the company knowingly cancels the name of any creditor entitled to object the reduction, knowingly misrepresents the nature or amount of the debt of or claim of any creditor, abates or is privy to any such concealment, misrepresentation as aforesaid, he shall be liable under section 447, that is penalty for fraud. That's it.